Welcome to the continuation of Colombia versus Peru Asylum case. Here you can see that the second point, a political offender means any person who has committed an act towards the detriment of the state and caused or attempted to cause harm to its sovereignty or integrity. Political offenders are allowed to asylum because several times the political offenders are rebels fighting against their cruel government or the dictatorship rule, or under their radar to be found and exterminated. In the present case, Peru argued that Victor was not a political offender but an unilateral qualification of Victor as a political offender by the Colombian government is invalid. Next, it was also argued that the Peruvian government that according to Article 2 of the Havana Convention, asylum should be granted in case of dire need or utmost emergency. For instance, when there is an immediate threat of extermination or persecution of the asylum seeker. In present case, the Peruvian government has not shown any such intention of persecuting Raul. On the contrary, the legal trial has been initiated against him in the Peruvian court. Hence, the asylum is invalid and against international law. Judgment of the International Court of Justice. With respect to the unilateral qualification of Raul, offence as a political offence, the International Court of Justice observed that in the normal scenario, the procedure is that the asylum granting state has the right to the provisional qualify an offence as a political offence, and the territorial state is entitled to consent to such qualification. In the present case, consent was denied by the Peruvian government, but the Colombian embassy made the qualification absolute even without consent. Moreover, the court was observed that the Havana Convention does not provide any right or entitlement to any of the states for the unilateral qualification of an offence as a political offence. It would be wrong to assert that Colombia had any right to make any such qualification. The Colombian government relied highly on the Montevideo Convention 1933, which allows such power to the state, to which the court observed that the Peru has neither signed nor ratified the Montevideo Convention. Moreover, the convention has not been ratified by the large number of states and its provisions are very rarely used. Hence, neither it is having a binding nature as a treaty nor as a general principles of international law. Conclusion. In this case, it was evolved that the concept of customary international law and added two essential ingredients to it. First is consistent and uniform usage. When you distinguish practice from a custom, the essential requirement is to prove that the practice has been going on for centuries in the same fashion and it is still a work guiding the way of the state. Hence, the court rightly concluded that Peru has the right over the custody of Victor Raul. Thank you.